I'll play my traditional role because being a congenital dissenter is in my DNA code.
Well, Ravi, if anyone thinks alike, then no one thinks much.
Thank you, Mr. Verma. I think the committee has done a very interesting exercise and needs to be commended for that exercise. However, there are a few points which I definitely need to bring to your attention, and I'll perhaps submit it later on as a written paper. Firstly, the allusion to religion and culture is very useful. However, the emphasis on it is, I think, perhaps misplaced. The undue emphasis, to be much more, because I think the objective impact on normative arguments as to whether the additional protocols should be adopted here in that aspect do not hold much ground. Also because in the present context, in India particular, there's a huge amount of discordance as to what is the true path in any religion. The Ramanujam debate, essay debate, is just one reflection of that, which is subterraneanly fairly volcanic. So I'd rather steer away from that in that. The second point I'd like to make is that India's principal objection to Protocol 2 in particular is that it's violative of India's sovereignty. I think one must be careful at giving overemphasis to the what Siddharth has already alluded to, some of the prehistoric notions in the Ministry of External Affairs on this particular issue. All international obligations are to an extent violative of sovereignty. You surrender a certain amount of sovereignty when you enter a treaty, and clearly you accept certain limitations. You accept certain, as they would say, Lakshman Rekhas in Hindi, when you do this. And this must be borne in mind that the international community already expects that by signing a protocol or a treaty, the sovereign has signaled that it believes that it's strong enough to uphold IHA law, international human rights law, and strong enough to win a conflict without having to violate these particular concepts and precepts. It's also very useful for us to ratify them because we gain, as has been said by previous speakers, the moral high ground, which, as was rightly alluded, nobody holds any monopoly on in today's present situation. As Siddharth very clearly said, almost most of IHL international human rights law has already passed into international customary law. So suddenly say that I am the emperor, please can you asking the waves to go back holds very little water. It must be remembered that India as a nation already has certain threshold obligations it must follow in any and every event, and this must never be forgotten. The other issue that in the time that I want to bring to attention is the issue of us coming up with the fairly semantic language in the Disturbed Areas Act and not recognizing internal conflicts in our ratification of other international instruments and the way we've dealt with it in the UN Human Rights Committee especially in so far as this discussion on the Disturbed Areas Act and the Armed Forces Special Powers Act, does not hold good anymore. It is, offers us very little protection, as the Universal Periodic Review most recently has shown to us. And our inability to even submit after our submission of our third periodic report to the UN Human Rights Committee, our inability to submit additional reports because we are not unable to address the earlier recommendations and concluding observations of that committee. I feel great amount of difficulty with accepting any recommendation about declarations. We don't use the word declarations. We don't use the word reservations. We are much more intelligent than most other governments. So we use the word declarations. We don't use the word reservations. And of course, all of you know what the difference is. It means a lot of difference. I think it is necessary for us that if we are to ratify an international convention, it must be done without any reservation or declaration. If we have strong objections to a particular issue, then we should do what the additional protocol says and provides for an amendment in Article 24 of the additional protocol 2. There is a procedure for amendment which it allows, and I think we should just adopt that. Because for reasons of time and brevity, I will just make one other point and not go on to lots of the other shopping list that I brought with me. The last point is the national border, and I'm glad that that Professor Verma has drawn your attention to it. Given the tribunalization of the law and many of the legal concepts in India, this is a very difficult and dangerous road to take. I would trust the superior courts of the country any day on issues of interpretation and not a government-appointed body, as we've seen how it has been misused in more than one case. I would defer in every instance to the superior courts of this country. Thank you very much.